So, as we said, we went back in time, in history, to see how the courts have dealt with willfully causing financial loss. And Justice Kwame Afreh had the opportunity and the occasion to deliver his ruling sometime in 2003, was it?
Yes, 2000.
Sometime in 2003 about the quality grain case. What is the quality grain case? It was a $24 million matter. What we are dealing with is $200 million. But that was a $24 million matter in which some money had been paid to an American lady. The American lady received the money that she was going to construct a rice farm in Ibrahim in the Volta region. The American lady's name is Renee Cotton. Renee Cotton collected 24 million cedis from the government of Ghana that she was going to do a rice farm. The money was paid by the Ministry of Finance, but it was a project under the Ministry of Agriculture. It turned out that Renee Cotton, after collecting the money, did not actually do the farm. And in 2001, when the Kufuor administration took over, $24 million had been paid to her, and Aveime farm had only a few machines and equipment there. I believe the farm is working now. I believe it was working now. But Aveime had just a few things. So the Attorney General of the day, incidentally, President Nana Akufo-Addo, was the Attorney General of the day. He took out a writ of prosecution, instructed the police, got a docket, and prosecution began. Prosecution began on willfully causing financial loss to the state. The people who had been prosecuted included the then Minister of Finance of the time, Richard Kwame Peprah, the Minister for Agriculture, the Honorable Ibrahim Adam, the Chief Director of the Ministry of Agriculture. Now you heard about certificates. Who signs them? So you can understand. The Chief Director of the Ministry of Agriculture, it was Dr. Samuel Dapa, and the Ghana Investment Promotion Center boss, Kwesi Ahwoi, the younger brother of Adom-Otchere. Kwesi Ahwoi was being prosecuted. And who else was there? Dr. Dapa, Ibrahim Adam, Kwesi Ada, Kwame Peprah. So I got all the names, yes. Yeah? Okay. So let's go and see what Justice Afreh explained willfully causing financial loss to the state to be. Interesting. He said as follows. Willful. He said, it is not enough for the prosecution to show that the accused person did a deliberate or voluntary act which caused a prohibited consequence. They, the prosecution, must also prove that the accused person foresaw the consequence and desired it, or took an unreasonable risk of it occurring. Let's get it again. It says, it's not enough. For you to prosecute somebody under causing financial loss to the state, you must do more than just showing that the accused person did a deliberate or voluntary act. You must show and prove that the accused person, he foresaw the consequence of what he was doing and desired that consequence, or he took an unreasonable risk of it occurring. Okay, I'll come to you quickly in a minute. Then it talks about financial loss. What's the meaning of financial loss? So let's first come to willful. How do you understand this?
So the importance of this definition, or the definition of this element, is that people may take willful to mean only an instance where somebody intentionally does something. So in this case, the defense argued that they are intentionally, or the offense presumes that an individual would intentionally want to cause loss. But Justice Afreh in this code says that no, if you saw a reasonable loss which may flow out of your action and you still went on to take that action, then you can still be found guilty of the offense of willfully causing financial loss.
So if you saw that if I did this, the country would lose.
Yes.
But I still did it.
Yes. You may have taken a risk. You may have thought that in doing so, the country may benefit. However, the risk was not reasonable. So your desire may not have been the country gaining a loss, or your desire may not have been the country incurring a loss. Your desire may have been for benefit. But if you were reckless enough not to weigh your options in such a manner that the outcome would be reasonably profitable, then you may be found guilty for the offense of willfully causing financial loss to the state.
I think that's a fantastic explanation by clap for the law student. I think that's a fantastic explanation. Powerful explanation. Okay, let's move on. Now, financial loss. Justice Afreh defines financial loss to mean this, because they said willfully causing financial loss to the state. So we know what willful is. Now we're looking at financial loss. It says, the word loss should be given its ordinary meaning of damage, deprivation, detriment, injury, or privation. And it is not necessary for me to consider whether the project is viable and will make profit if properly managed. That's very deep. What does it mean?
So he's saying that so long as there is a loss, what you have to prove is that there was a loss incurred by the state.
What the prosecution has to
What the
prove.
prosecution has to prove. So it does not lie in the place of the defendants or the accused to say that, but if the project was managed properly, or if this was done, then we would have got a benefit. So long as you knew the losses that could have flowed, so long as you took advantage, so long as you did the specific act, and there was a loss. So in this instance, one person may argue that, well, it is possible that the government serving as a guarantor for Mrs. Cotton to have the farm. Yes, the farm would have benefited, would have created jobs. But was there a loss? Yes, there was a loss, and that is all we are interested in.
Interesting. Let's move on. Causation. He says that, why are we looking at causation here?
Yes, so the act that caused the loss, that the loss should have been caused by your act. So in this instance, it was signing off as a guarantor for an individual, that is in the quality grain, for an individual who did not really investigate her background. So that act of signing as a guarantor was what caused the loss of the farm not, or the mills not being put up in the farm at Aveime.
Okay, let's look at this. It says causation.
Yes.
For the prosecution to succeed, it must show that the state incurred a financial loss through the action or omission of the accused person. The state, we must show that the financial loss was occasioned for the prosecution to succeed. Okay, let's move on. It continues to say that of the more than a dozen meanings of the word through, the most appropriate or relevant for this case are those indicating cause, reason, motive, in consequence of, by reason of, on account of, owing to, as a result of, by means of. So this causation, the prosecution must be able to show that as a result of your action, the Republic of Ghana lost this amount of money.
Exactly.
That is enough for causation to stand.
Yes.
And attached to willful.
Exactly.
Then financial loss.
Yes.
You are going to jail.
Yes.
That's interesting. There's more. It says, in other words, it must be proved that the cause of the state's financial loss is the action or omission of the accused person. There must be a direct causal link between the action or omission of the accused person and the financial loss incurred by the state. It is not enough for the prosecution to show that the accused actions or omissions could have caused or contributed to the loss. It must prove that it did cause or contribute to the loss. So it must substantially prove, not just simple, not association. It must say that you, X and Y, it is your act. Okay.
So you have to demonstrate that indeed this act caused the loss, not
the prosecution must demonstrate.
The prosecution must demonstrate. It's not enough to say that it is probable or it is possible or in certain instances this act causes the loss. It's not enough. You must show that in that specific instance it was acts so and so that caused the loss. Reason the second accused in this case was acquitted. The reason being that as the chief director...
Second accused being Dr. Dapa, the chief director of the Ministry of Agric.
Exactly. Because the court found that, he was acting under the influence of the Minister of Agric. And as a civil servant, civil servants are supposed to have a sort of bland, non-partisan, neutral stance. And they act at the pleasure of the executive. And so the court was of the view that if that is the case, then he could not have caused anything because he was simply acting as an involuntary agent of his
so
boss
that
at
is
the
the
time.
reason why Dr. Dapa, the chief director, was acquitted.
Yes.
That he was not acting on his own.
Yes.
He was acting on the instructions of the minister.
So he was
Who
an
was
extension.
Ibrahim Adam, the first accused.
Yes, at the time. So he was an extension of the rules, the judgment of Ibrahim Adams and co. And indeed, at the meeting where the accused or the prosecution was charging them for conspiracy to willfully cause financial loss to the state, it was demonstrated that as a chief director of the ministry, he did not even have a say. He was just supposed to appear, take notes, and then direct to the minister.
Okay, let's move on. So this is action or omission.
Yes.
And Justice Afreh relies on another case, Malam Ali Yusuf versus Malam Ali Yusuf Isa versus the Republic, unreported. At that time, it was unreported. Yes. 25th June 2001. The Court of Appeal, isn't it? So that must be the appeal. The Court of Appeal held that the words or omission in Section 179A of Act 29, which is the criminal code.
Yeah. So it starts from the slide before.
Oh, it starts from the slide before?
Yes.
Okay, so the accused person must have taken some action, or must have done some act, or omitted to take some action, or to do some act. I do not think it is necessary to define the word action or act, except to say that under the Interpretation Act, 1960, CA 4, Section 32(1), Act includes omission. Okay, great. In Malam Ali Yusuf Isa versus the Republic, unreported, 25th June 2021, the Court of Appeal held that the words or omission in Section 1793A of Act 29, the Criminal Code, which is the provision under consideration, omission were obviously added for the avoidance of doubt and ex abundantia cautela, because by Section 32(1) of the Interpretation Act 1960, in an enactment, act includes an omission, and references to the doing of an act shall be construed accordingly.
Yes.
Explain.
So if you see the wording of the offense, it says willfully causing. So it is likely for someone to argue that willfully causing means I should have done a positive act. That is actually doing
positive,
something.
not the English positive, but legal positive.
Legal positive.
That's actually doing something.
Not just sitting back. But he is saying no. An act includes an omission in the sense that if you sit and fold your arms when you have as a responsibility, as a government agent, whatever, a minister, to do something and the state incurs a loss, that's sitting back and folding your arms and watching whatever goes on would be construed to be an act, and you fall squarely within the offense of willfully causing financial loss. So even though you didn't do anything, just because you did not do anything when you had the responsibility to do something, you will be found liable.
So it says the words or omission do not create a separate or alternative offense. Okay, I think we've dealt with that. Okay, so that's the last one. Okay, so this is it. This is the case of Rene Cotton. It's entitled Ibrahim, the Republic versus Ibrahim Adam and 4 others. Is it 5 others?
4 others.
Ibrahim Adam and 4 others. Richard Kwame Peprah, Dr. Samuel Dapa, Kwesi Ahwoi of the Ghana Investment Promotion Center at the time. Kwesi Ahwoi succeeded on the submission of no case, and that's why I said this case has the outcome of all the all the 3 possible outcomes of a criminal process: conviction, acquittal, and the submission of no case. So maybe law students will do well to have a look at this case. Maybe it will come in the Makola entrance exam. Just maybe. You doubt. What are you thinking are the big ones for the Makola entrance exam?
I'm really looking at...
Let's spoil the question paper. If they've done it right, let's spoil it. Election petition?
Election, yes. Particularly citizenship and
the new one. Citizen and allegiance?
Allegiance, citizenship.
What about Article 78, vetting? The vetting of ministers? Do you think...
it has not crossed my mind.
It hasn't crossed your mind? Okay, have a look at it. Have a look at it. Okay, so the law students, come to me. I'll show you which one is coming. What date is the exam, by the way?
24th August, 10
24th August. Good luck to everybody. We'll do a rehearsal on Good Evening Ghana. You go, you just master, you just smash it away. You blow it. Okay.